Welcome everyone. My name is Jimmy Goulet. I'm a professor here at Notre Dame Law School, and I'm the director of the Exoneration Justice Clinic. And I would like to welcome you to day 2 of Death Penalty Abolition Week. And the theme of today's presentation is the death penalty and innocence. The death penalty carries the inherent risk of executing an innocent person. Since 1973, at least 200 people who were wrongfully convicted and sentenced to death in the United States have been exonerated. So let me just repeat that. I want you to think about that for a moment. Since 1973, 200 individuals that were convicted of capital murder, that were sentenced to death, that were on death row, were exonerated. And that means that they were innocent. They did not commit the crime for which they were convicted. But yet, they were going to be executed. And but for the work of lawyers like Erin Barnhart, who we're going to hear from in a minute, innocence clinics like the Exoneration Justice Clinic and the Innocence Project in New York, the so-called lucky ones, they could have been wrongfully executed by the state. The Death Penalty Information Center states that for every 8 people executed in the United States, 1 person wrongfully condemned to death has been exonerated. So 1 to 8. For every 8 people that have been executed in the United States, 1 person wrongfully condemned to death has been exonerated. So that raises the question, is it worth the price? I mean, so the risk, the substantial risk that 1 of 8 could be innocent and wrongfully executed. Let me put that number in perspective. As of March 20th, 2025, at least 10 people have been executed in the United States, and 11 executions are scheduled for later this year. And so, by the way, for the first 3 months of the year, we've had 10 executions. It's a significantly high number, relatively speaking. And by the end of the year, there could be a total of 21 individuals that could be executed. So if you take the number of 1 to 8, then at least 2 of those potentially, there's a substantial risk, could be innocent and executed by the state, and the number could be even higher. There's another disturbing dimension to the issue of innocence and the death penalty, and that's exonerations by race. So if you take the number of 200 exonerations of people on death row and you break that number down by ethnicity, 108 of the 200 exonerations were black inmates or African Americans. So more than half of the people that were exonerated were to be executed by the state were black, despite the fact that black Americans represent only 15% or approximately 15% of the American population. So 15% of the American population, but over 50% of the exonerations of people that were on death row. So it raises a very serious question for us to consider, and we're going to discuss this today in greater detail. Is it worth the price? If the criminal justice system cannot guarantee that when they execute someone who has been convicted of a capital offense, if they cannot guarantee that that person is guilty, actually guilty, committed the crime, is that a compelling argument for the abolition of the death penalty? Or as a society, are we willing to just accept that as just an acceptable rate of error? Like, so what? If it's only 1 of 8, we're willing to accept that as a society, that 1 of 8 individuals could conceivably be put to death by the state who are actually innocent. So we have 2 very special guests here today to discuss this issue, and from a very fact-specific, perspective. We're not talking about this theoretically, but this is a real case, real living, breathing human being who was on death row, who was going to be executed by the state, and then through the hard work of his attorney, Erin Barnhart, was exonerated and spared from execution. So I'm going to ask Alex, one of the students in the Raglan, one of the students of the Exoneration Justice Clinic, if she'd come forward and introduce both of our speakers. And then I'm going to turn the time over to Erin Barnhart. I just want to say that, Erin, welcome back to Notre Dame Law School. As you know, Erin is a Notre Dame law graduate. She graduated from Notre Dame in 2005, and it's a pleasure to have you back and to share the story and Lamont's story with us. So thank you.
Good afternoon. Welcome to the second event of Notre Dame's Death Penalty Abolition Week. My name is Alex Ragland, and I'm the president of Notre Dame Law School's Death Penalty Abolition Society. Today, I have the absolute honor of welcoming our esteemed guests, Lamont Hunter and Erin Barnhart. As Professor Gurule mentioned, since 1973, over 200 people have been wrongfully convicted, sentenced to death row, and then exonerated. The issue of wrongful conviction and capital punishment are closely intertwined. Our speakers today personify this type of gross miscarriage of justice and the fight against it. Lamont Hunter was convicted in 2007 in the death of his son, who suffered fatal injuries after accidentally falling down the stairs. Lamont Hunter spent 16 years in death row in Ohio before his capital conviction was vacated and he was granted a new trial. After almost 2 decades in prison, Lamont agreed to a plea deal in which he would plead guilty to lesser charges of involuntary manslaughter and child endangerment. As part of his plea deal, Lamont was sentenced to time served, and he finally obtained his freedom. Lamont's attorney, Erin Barnhart, is an assistant federal public defender for the Southern District of Ohio's Capital Habeas Unit. Erin represents death row inmates in federal habeas and civil rights litigation, as well as state clemency matters. Erin is a Notre Dame Law School graduate, so welcome back, and former editor of the Notre Dame Law Review. Today's event is hosted by the Notre Dame Law School Exoneration Justice Clinic and the Claw Institute for Civil and Human Rights, and is co-sponsored by the Black Law Students Association, the ACLU of Notre Dame, the Notre Dame Exoneration Project, and the Death Penalty Abolition Society. Please help me welcome Lamont Hunter and Erin Barnhart.
Well, thank you, everyone. Can you say something?
Just thank you for having us, and I'm honored to be here.
Law school looks a lot different than it did in 2005, gotta say. It's pretty nice. So before we begin, I did want to just again thank Lamont for being here to share his story. You know, Lamont went through intense trauma, both in losing Trustin and then enduring, you know, his time in custody and on death row. And so I never want to lose sight of the fact that, you know, he really does a service to all of us by reliving that and telling his story today. So we're really honored to have him give that gift to all of us. So thank you, Lamont.
Of course, thank you.
To begin, we thought we would just tell you Lamont's story. First kind of from his perspective, and then legally what happened that ended him up here in front of you today, and tell you, you know, a little bit more about the type of case that ended Lamont on death row, which is a shaken baby case, and then, you know, a little bit kind of just about death penalty cases in general. And we definitely want to talk to the students in the room about how to do this kind of work. And Lamont is great about giving advice to law students who want to be criminal defense attorneys about how to be good attorneys. And so we really hope that you will ask questions about that. So we'll start with Lamont talking about one of the worst days of his life.
Thank you, Erin. Again, I want to say thanks for having me. I really appreciate the invite to share my story. I guess I go back to the day in question, the morning in question was January 19th, 2006, one of the worst days of my life. Me and my girlfriend lived in that house right there. Trustin was the youngest of the children that we had. He's not my biological son, but I was acting as his father, you know. Me and her have a daughter together. She was 9 months old at the time this tragic accident happened. So my day started off as a normal day. It was winter time, so I wasn't working. I was on unemployment because the work that I did at the time was seasonal. So I'm home with the kids doing chores while, you know, the older children went off to school and my girlfriend went off to work. So I get my day started. I get Trustin situated in the living room in my favorite chair, recliner chair, which he liked to sit in. Get him some breakfast, a sippy cup set up, and put his favorite movie on. He really loved trains and dinosaurs, so I put his favorite movie, which was Jurassic Park, on for him. And I decided to get busy around the house doing my, you know, normal chores. I have my 9-month-old daughter, Trinity, so I figured I'd pick up where I left off the day before with my chores, which was laundry. And so I decided to go downstairs and finish that up. But I couldn't leave her upstairs. She's 9 months old, so I take her downstairs with me. And I had a little man cave down here where me and my brothers, my father and us will go watch, you know, ball games and, you know, hang out and stuff. So it's safe over there for her. I put her over there and I go to get started doing the laundry. And as I get over towards the laundry area, I hear Trustin running across the floor above my head. And I'm looking like, what's going on? And next thing I know, he's tumbling down the stairs. And I couldn't do nothing but run over to the stairs. He's there on the floor, there in a bad way, actually. When I reach him, I noticed, the first thing I noticed was his eyes fluttering, fluttering towards the back of his head, and labored breathing. So I scoop him up and in the panic, just run up the stairs with him and try to resuscitate him, you know, trusting, you know, shaking him and stuff, just gently trying to, you know, bring him back because his eyes were scared me. So I get him upstairs and put him on the couch, floor, you know, whatever, and try to splash water on his face and bring him back. And I noticed that he was still, you know, had labor trying to take a breath. And so I try to do CPR, which I'm not trained in. Still, I need to be at this point. But I try to open his mouth and blow in his mouth, and I noticed his teeth was clenched, like, you know, like that. And so I forced his mouth open, and I noticed sausage that I had given him was lodged in the back of his throat, his mouth. So I plucked it out and started blowing in his mouth. And get the phone, call his mother. She worked like a block up the street at the Speedway, and she get home. We called the paramedics, and he's just in a bad way. I left my daughter down in the basement. I was so scared and in a panic. I had to go back and down and get her, and it was just a bad time that day. So the paramedics come, trying to stay focused here, guys. It's hard reliving that incident, but that accident. But so the paramedics come. They immediately start working on him and rush him to the ambulance, and we all go off towards the Children's Hospital. We get to Children's Hospital. He's still not, you know, there's no, at this time we didn't know, but there was still no brain function going on because of the injuries he sustained falling down the stairs. We now know. So we get to the hospital, And of course, the staff wants to know how did this happen, what's going on, getting as much information as they could to try to help him. And I told them what happened. And they took that information and passed it along to investigators at the hospital. And they wanted to talk to me, and they approached me and his mother. And I told them what happened, and they didn't believe what I told them had happened, even at that time. So we didn't talk anymore. Trustin's still in a bad way. They're trying to save his life. And a day or two later, after that, a day after that, his mother decided to just take the life support off of him and let him go. It was very hard to do. And the day after that, I learned that law enforcement wants to talk to me. They have a warrant for my arrest. And so I contacted an attorney and called them and turned myself in and let my statement stand that I made at the hospital, because my attorney told me at this point, you told them what happened and let that be it. And so we go from there and they arrest me and the legal journey begins. And what a journey it's been. They arrest me from the detective's offices and take me over to the county jail, where I'm being booked into the county jail. On the way from where the detectives' offices are to the county jail, I asked them, what is my charges? And they told me my charges were child endangering and aggravated murder. And of course that hit hard. It hit me hard, and I'm in a bad way. I'm emotionally distressed to be accused and charged with something that I didn't do. So I'm going through booking, and while I'm going through booking, I didn't know that detectives and things, prosecutors and things, was at my house. So when the first chance I get to use the phone, I call my house, to check on his mother, my girlfriend, and give her the information to pass along to my family, my mother, my siblings, my parents. So when I called, my girlfriend's friend answered the phone, and she wouldn't give my girlfriend the phone. And finally, she get on the phone. I'm saying, "What's going on?" She said, "Well, the police are here. The detectives are here, and they don't want us to talk. They don't want me to talk to you." And they hung up the phone on me, and I got ushered back into a cell and ushered into a lockdown facility, isolation facility. The whole, for what I don't know, but I later found out, it's because the prosecutors and the detectives called down to the jail and told the jail staff to take my phone privileges so that I could talk to her, because what they were doing was trying to talk to her and turn her against me and whatever. But that's how the legal journey began. Erin, you want to go for it?
Yeah. And so I think just one other piece before we get to the trial is, Lamont's in that isolation cell. And
Oh yeah.
from it, he can see the television out on the range.
Yeah, they got a TV screen out on the range. You're locked in the cell, but out on the range there's phones, shower, and there's a TV. A common area where you can tables and chairs where you can sit. That everybody who's in this isolation unit can go out for an hour a day. So I'm standing in the door in this narrow little window, and I'm looking at just looking out the door, and I'm looking at the TV, and it was weird. I'm looking at the TV, and the news was on, and my face popped up on the screen, and okay, I said, okay, the media has got a hold of this now, and I see the charges that I've been charged with. It was child endangering and an aggravated murder, and then they added a rape charge. And I'm thinking, wait, they got that wrong. That's a typo. That's an error. That can't be a rape charge. I understood my charges when they told me on the way over here. So we go from there.
Yeah. And so the rape charge was based on the fact that Trustin had some bleeding coming from his anal and rectal area. And then at the autopsy, the coroner discovered some puncture wounds in his rectum. There were 3 of them. And at trial, she testified it looked like it could have been made by an object, like a pencil. And so the theory was Lamont had raped him like with an object. And then, because he was upset, then Lamont, beat him up, abused him. He used phrases like swung him around like a baseball bat. And so Lamont's attorneys kept asking him, how did he get these injuries? And
Right.
of course, Lamont had no explanation whatsoever
Absolutely.
for that. He had helped, Trustin was potty training, so he had assisted him with that. He hadn't seen any blood or anything like that. So Lamont was not able to provide any explanation for that.
It just totally shocked me that was literally one of my charges. Once I learned that they was charging me with that, and I'm like, my attorneys are asking me, so tell us about the rape. I said, you tell me about the rape. I don't know nothing about a rape. What happened with him? What are you talking about? And that's when I learned about the puncture wounds that was there. And it's just perplexed me.
Yeah, and of course that made his case all the more aggravated, and the prosecutors used to have to say, look, even if you believe Lamont and thought that Trustin did fall down the stairs, like there's no explanation for this blood, and so it couldn't have been an accident. So at trial, the prosecutors and the child abuse pediatrician relied on this shaken baby syndrome. Who's heard of that before? A lot of you.
Good. We know it's junk science now, right?
So, it's kind of like junk science does, it evolves as it gets criticized. So in its earliest form, it was based on what's called the triad. And if you presented with the 3 symptoms, it was you shook the baby and that's it. As it's been challenged, it's sort of morphed, and now it's called abusive head trauma, maybe with impact or without impact, because they're trying to navigate every time defense attorneys show that their theory is, not scientific. So basically it's 3 things. It's that you have bleeding in the brain, it's called subdural hematoma. You have brain swelling or edema, and then you have bleeding on the back of your eye, which is called retina hemorrhages. But all these 3 things are also very common anytime you have a head injury, because your skull is a solid box, and if you have any insult to the brain, and that causes swelling. If you get any blood in the brain, there's nowhere for it to go, and so that blocks off oxygen from the blood circulating. So then that results in brain death, and any pressure in the brain also squeezes on the retinal nerve, and that causes bleeding too. So the prosecution presented that testimony, and Lamont's trial attorney, unfortunately, was not up to snuff.
Yeah, it was the worst. I wouldn't recommend allowing anybody to represent you and defend you who's being investigated by the federal government for criminal charges of himself. He's trying to save their own life for some very bad charges.
I mean, he didn't let Lamont know that was going on at the time. So
completely hid it from him.
So he basically did no work on Lamont's case. He didn't interview any witnesses or hire an investigator himself to do any interviews. He didn't request the medical records and review them, and he didn't hire an expert to do that for him, much less to testify in court to rebut the state's experts. So in some ways, the trial court, he did also waive jury, which is generally not a good thing to do in death penalty cases. So Lamont was tried by a 3-judge panel. So it was sort of like the judges didn't really have an option, because they kind of had this unrebutted testimony from the state's witnesses that there was no way for these injuries to have happened short of abuse or like a high impact car accident, but they certainly couldn't have happened the way Lamont said, from falling down the stairs. Lamont was convicted in state court in Ohio and had all of his appeals in state court, which is a direct appeal, and anyone who works in the exoneration justice clinic might be familiar with the phrase post-conviction, which is like a parallel process, and got no relief there whatsoever. In fact, got no process there, no discovery, no hearing, nothing, which is not uncommon. And so then after all that finished was the first time my office could get involved in filing a petition for writ of habeas corpus in federal court. And we did so, and we needed discovery. We needed to do all the stuff that his trial attorney hadn't done. And unfortunately, that is a lot because in these type of cases, for an expert to do a correct assessment, they need all the medical records of the child, the prenatal records. They need family records because a lot of things that present in this triad could have other causes like genetic components, other kinds of diseases. You know, you might have an injury during the birthing process that's sort of latent and then gets triggered. So we were asked for a ton of stuff, and our federal district judge was a little bit taken back by that. But thankfully, he let us sort of do a little staged discovery and let us depose Lamont's trial attorney, who, to his credit and to his ego,
Mainly his ego.
you know, said like, yeah, I don't think I need an expert. Like, I could do it myself in cross-examination, and, you know, admitted that he hadn't done anything, which was great for us because that really showed how ineffective he was. And so when our federal judge looked at that deposition, he saw how ineffective this attorney was. And this is just a little portion of his opinion, comparing it to a Sixth Circuit case that also found ineffective assistance, and sort of comparing it to how he had done even less than that case. And at the very end, kind of like the key of all of it is it said he appeared to have decided his strategy of shunning experts in favor of cross-examination, not as a result of any investigation, but in lieu of any investigation. And if you know anything about Strickland versus Washington, which is like the seminal Supreme Court case about ineffective assistance, like that's the key. You can't make a strategic decision without having done the investigation to justify that strategy. And his attorney didn't do that. He just said, I'm not even going to bother. I just know I don't need any experts. So because of that, then we were allowed to do the full discovery that we had asked for, get all the medical records we needed, and then also get to depose the coroner and the child abuse pediatrician. So before that had happened, of course, just, you know, kind of as pretty obvious, but back to the trial, as I mentioned, you know, the court really had no choice. Lamont was convicted on all 3 counts, and then also sentenced to death. And we put that date up there, June 15th, 2007, as one of the worst days of his life, because it happened to have been my birthday, before I was even his attorney, before I was even a capital habeas lawyer. But then on that same day in 2003 is when Lamont was released from custody. Yes. So I highly recommend walking a former death row client out of custody on your birthday. It's like the best way to celebrate.
Yes, that was an amazing day right there. With my children. Oh my God, that was my granddaughter, one of my grandchildren.
First time
getting to meet her and see her. Now I can't get rid of her. Pop this and pop that. But yeah, that was an amazing day right there. And like Erin said, I highly suggest, first, be amazing Erin, y'all. She has been very, very patient, graceful with me. And she, like she just described, the state process, appellate process, and the bilateral appeals, post-conviction and direct appeal. going through that before Erin comes along onto the case in Habeas, you know, it's kind of hard, it's hard to describe. I'm traumatized first and foremost. Anybody who goes through a public death penalty trial, it's very humiliating and traumatizing, and it is torturous. So when I arrived on death row, I was still in a haze. I'm a wreck, trying to, just navigate this thing. The appeal process begins. I get sets of attorneys, and they do what they can do, not what they should have. What they should have been allowed to do. Erin just mentioned as far as discovery and all the stuff that we got in Habeas, we could have got some of that done in at least state appeal. So I trying to balance this this journey and my beautiful supportive family that's along for the ride with me. It was very difficult. And the courts is just, not hearing it, not listening, not hearing nothing. And it's just frustrating. I know the truth. My family's right with me, and it's just very frustrating. But after that, we get into Habeas, and Erin and her office and team comes along. And Erin, when I say she's been very gracious and patient with me, I was diagnosed with severe anxiety, and Erin has been patient to explain the procedural process going forward in habeas corpus, and outside of the state appeals. And I've never had an attorney do that up to this point, and it was like a breath of fresh air when she took time to explain the process and the procedural hurdles, not all hurdles, but going forward. And with my family, she took time to explain it to my family, meet with my family. Nobody had done that up to that point, and it was at least I felt like somebody was listening at this time, and she did. She heard me, and we got to work. I tried to be as productive as I could in my own defense with the team. I took it upon myself to ask all three of my children right there, to help me take a correspondence course to earn a paralegal certificate. And they helped. And I earned a paralegal certificate just so that I could understand the legal terminology, the language, because sitting through that humiliating death penalty trial traumatized me, because at that time I didn't know that the language is the weapon inside of the courtroom, and the everybody else understands it except for I didn't understand it, so I didn't want that going forward. And Erin would explain the legal terminology to me as well, and so we got to work, and she's been amazing. She at this point, I'd like to mention, at that point right there, this joyous moment we had right there, Erin could have been, and she could have said, okay, Lamont, congratulations, good luck in your life, and, I wish you the best. But here we are almost 2 years later, and she's still here. She won't go, no.
Please.
My family loves her. She has pulled me back off the edge so many times. We have had so many strong conversations over the phone because of my anxiety. During that time, sitting on death row is a very dark place. I'm gonna let you, get back to it, Erin. Death row is a very dark place. It's where hope goes to die, I like to say, because there's no hope. A lot of trauma, a lot of mental illness, a lot of despair, and in these dark days, I met a beautiful friend, Teresa, who's here today and in support of me. And they surprised me. I didn't know she was coming today. She walked up behind me. But on death row, you have to have like I have a family, a very supportive family. I was blessed to be born in the family that I was born into. But I have to admit, early in the process of the journey on death row, when I first get to death row, maybe a year in or so, I understand, the society looks at me like they call death row inmates the worst of the worst. And it's just a bad look. And I contemplated in my mind cutting off communication with my family to spare them any more hurt moving forward in the journey. What convinced me not to do it was my beautiful mother, who is now 85 years old. And I knew the pain that it would give her not to be able to be there for me and support me. So I decided not to do that. But it's very much needed in those situations. A lot of people on death row don't have family. Family has abandoned them because of the media hype and you looked at it in the community as the worst of the worst. This is a very you've been accused of some of the most heinous things a person could ever be accused of. And some families run and cut and run. My family would never have.
It's expensive
It's
to have
very
a family
expensive.
member incarcerated.
Very expensive. The incarceration prison industry complex it targets your family and friends and subject them to these outrageous prices to even communicate with your loved one that's in prison.
Or buy toothpaste.
Or buy toothpaste or any essentials, that you need to live like anybody else would in society. Yeah, I would. I can talk forever about that. So, but I won't go on too much about that. But having advocacy, an advocate like Erin, who cares about the right thing and truth and justice, is not the norm. I just have to say it's not the norm because the system is so bogged down with all this work that people miss. Human beings, lawyers, attorneys are human beings, and things get missed, and the system is so bogged down. It's just like, okay, we just move on. But you have attorneys like Erin who don't do that. She do the right thing, and she's amazing. I've given her the nickname, the Amazing Erin, because they don't come like Erin no more. They don't come like that no more. So I'll stop there. Okay, I'll stop there. And I can't praise her enough.
I mean, but I think there's a couple points to take from that. And one is, there's multi-layered problems with the indigent defense system, capital system. There's so many. But one is, there's a lot of problems. You're not always getting the best attorneys in it, and there's no accountability because who's going to listen to someone on death row who says, everyone's expected to be convicted who's brought on a capital trial, right?
Exactly.
So when you're saying like my attorney didn't do what they were supposed to do, you have no political capital, ironically. Capital,
Absolutely.
you know, for people to listen to you. So, I mean, I do think that I might have been the first attorney who like considered that Lamont actually was innocent and listened to him. And so I reached out to an expert, you know, in shaken baby science, and found out like, oh yeah, this is like, you know, crap. I didn't know anything about it, but she read the transcripts and pointed out all these things that the state experts said that are not scientifically based. And so it's like, okay, well, we need to dig into this. You know, we can't just assume that he is guilty. And sure enough, we start digging in and we find it. So, you know, and I think that that's a very important lesson is like no assumptions. And if you start doing criminal defense work and, you know, especially innocence work, you will find like mistakes all over the place like that because people are overburdened or lazy or not trained or whatever and don't take the time to go carefully through things. So just sort of like never assume that it's been done correctly. Never assume that just because the prosecution has brought a case or they have an expert who is very authoritatively saying something that they're right, because it's often not the case. So, you know, question everything. And just, you know, I'll add on to the point Lamont is making. Obviously, if you can be you know, a criminal defense attorney, a post-conviction lawyer, like wonderful. It's the best job in the world, hands down. But even if you can't, you know, Teresa was a pen pal for Lamont. She's not a lawyer. She just like is a wonderful person who,
I'm
you know,
a second grade teacher.
It's a beautiful soul.
But you can be like a corporate lawyer and still like be, you know, you can go on a website and become a pen pal for somebody who's incarcerated. Death penalty clients have a right to attorneys like no one else does once they're out of trial, you know, maybe direct appeal, but like they're trying to navigate this habeas system by themselves, which is insane. But even if you're not representing them, like you can just be a pen pal to someone and like see them as a person and offer that bit of support and help to them. So just something to keep in mind. I'll quickly go through a little bit more about Lamont's case, so you can, you know, see what we learned when we actually started digging into Lamont's case. As Lamont mentioned, like he got a new trial. The prosecution didn't even oppose our new trial motion once we presented them with the evidence. You know, so how did we get there? Okay, so as I mentioned, we got to depose the coroner and the child abuse pediatrician through the federal habeas discovery process. So one thing we did is we showed the coroner actual pictures of the staircase that Trustin fell down. She'd never seen them. As it turns out, that mattered. One of the things she noticed was, as you can see on the right side of the picture, the stairs going into the basement were against the exterior wall of the house. And there's this like concrete cinder block wall that juts out and makes a right angle. And as soon as she saw that, she said, oh, well, Trustin had this like long linear bruise on his back, and that does kind of match up with that. And then she also noticed like there's this throw rug there. And she also admitted that, first of all, no one had told her Lamont's statement about what happened. So she didn't know. Lamont said, I had heard Trustin running across the floor. And she admitted, I hadn't thought about the child could have been running. So I was just thinking about the child standing on top of the stairs and falling down when I said he couldn't have gotten these injuries. But now that I think about a 3-year-old child who could have been running, maybe even slipped on this throw rug, it is possible. She wasn't a child abuse, you know, a shaken baby zealot like the child abuse pediatrician. She was pretty straight up and said, like, it is actually possible to get the head injuries that Trustin got from falling down the stairs. And now that I see the wall, like, yeah, it is possible that what happened, that these fatal injuries could have happened. So I'm going to officially change my opinion and say that this isn't a homicide. The cause of death is undetermined. So she said that on the record in her deposition first. And then we showed her what we had found in the medical records. And this is what I mean. Like, if his attorney had just done this himself or hired an expert to do it at trial, Lamont never would have gone to prison, I believe. So our investigator, Pam Swanson, as soon as we got the case, does what she always does and starts looking through the records. And these are the admission notes when Trustin first arrives to the emergency room. It's a little hard to read here, but what this says here is blood noted on rectum, while checking rectal temperature. Unable to obtain rectal temperature ×3. And another note said,
Saved my life.
unable to obtain rectal temperature, no further rectal temperature per doctor. And here's what the coroner said. Oh, she actually said, oh, goody. We see 3 puncture wounds in the rectum, and they're trying 3 times to shove that in there to get a rectal temperature. So she changed her opinion on the cause of those injuries.
Where the rape charges come from.
Yeah. She said, well, they're still inflicted, but they were inflicted by medical personnel and not Lamont. We found out that although she had subpoenaed these records from the hospital, they were never delivered to the coroner's office. So I really think nobody looked at these medical records until they got to our office, like 8 years after Lamont had been convicted. And obviously, if they had, and while she was on the stand, someone showed them to her, this is what her testimony would have been. So we were able to just find that out ourselves. But again, you need experts. And so we hired an expert who happened to be an emergency room physician at this hospital. And so he explained to us some other things that, because of course the prosecutor said like, well, he arrived at the hospital bleeding because they still found blood in his underwear. And we said, well, you checked his rectal tone a number of times and nobody noted any blood. And I even said this to the child abuse pediatrician who was unmoved by the coroner changing her opinion. And I had all sorts of theories about how checking a rectal temperature 3 times maybe could just mean using an electronic thermometer and pushing the button 3 times. And then she finally admitted that she really shouldn't be opining about that because she actually didn't even see the wounds because they were only done in the autopsy. And so then she retreated from that. Anyway, I said, well, like, wouldn't you have to like get pretty close to assess the rectal tone? And she said, I was like, well, how far? You kind of just eyeball it. And I was like, how far away can you be? And she doesn't know what she's talking about, right? Again, this is this person who's just like doing whatever she can to shore up her diagnosis. Anyway, our expert, who actually works in the emergency room, unlike the child abuse pediatrician, explained the process for when someone arrives in the emergency room and what they go through this assessment, because rectal tone is very important to know about brain functioning. And so he said that the examiner, after checking, he says like ABC, after you check a bunch of things, you then insert a gloved finger into the rectum to look for rectal tone and the presence or absence of blood. So absolutely, if Trustin had arrived bleeding, like this would have been found and noted. That same expert also was a biomechanical engineer who we hired to go to, that's where we had those pictures from the staircase, to go to the staircase and measure things. It's something about like the elasticity of a surface, like how much something will bounce off of it, and do a bunch of calculations in this computer program and determine, he said like, the average, someone of Trustin's height and weight and the average running speed of a 3-year-old, and in those parameters, could you generate the force necessary to cause the injuries Trustin got? Of course you can. Okay, but the child abuse expert, she was starting to tell me, her theories about it, and I said, oh, so you're talking about like when you say mechanism, because she kept saying like the injuries don't match the mechanism of injury that Mr. Hunter described, and so I said, well, when you're talking about mechanism, that kind of sounds like you're talking about force, right? Like physics. Oh, no. I'm not going to some biomechanics. I'm talking about mechanism. And this is how you know Shaken Baby is like junk science, because they explicitly disavow physics or force or anything like that, which is insane because that's what it's all about.
Absolutely.
So, I mean, I could go on for a long time about that too, but I won't. Anyway, I'm going to skip over some of the more specifics about this too. But I will just say that one of the things that has caused Shaken Baby to lose some of its credibility is that there is video evidence. Don't worry, I'm not going to play these videos. Now that people have cell phones, like we have video evidence of children sustaining these injuries, not from abuse, but actually from shortfalls, like off of this 3-foot little Tykes like play equipment. A lot of people think like you need a really long fall to get the injury, but it's actually not true. It's all about like rotational injury. If you think of like the skull and the brain inside of it, it really just needs like a short little twist. Because if you think of like a spot in the center of the brain and the outside, when you do that, the spot on the center of the brain moves just a little, but the outside moves a lot, right? Well, that's what causes the brain tissue to tear, the blood to come out and give that subdural hematoma. So it's actually shortfalls like off of a couch or a bed, normal household injuries that can be like very dangerous for children. But like this child abuse pediatrician, I don't know, one quick story. So she's like citing these articles about how children don't die from stair falls, like they're not fatal. And I said, well, how do you get this data? And she said, oh, well, you get the admission records from these hospitals of children who are admitted from falling downstairs and they just don't die from it. They're not fatal. And I said, okay, but like, would Trustin's case be included in this data set? She's like, what do you mean? I said, well, you don't believe Mr. Hunter that it's a stair fall. So would you classify it as a stair fall? She said, oh, that's a good point. No kidding. Because you're like, you're making the data that you're using to like exclude the data, you know, and she'll say like, we have no error rate in our work because like every time we testify, they get convicted. So that proves I'm right, but they're only getting convicted because you're testifying. So anyway, okay. Who knows who this is? You can shout it out. Right, Robert Roberson. He's a death row inmate in Texas. In December, he came within 20 minutes and about 20 steps of being executed. His case is eerily similar to Lamont's. It's also a shaken baby case. His daughter was an infant, not a toddler like Trustin. But what do you know? There's an allegation of sexual abuse in his case too. You'd be shocked at how many shaken baby cases have these sexual abuse allegations. In his case, I believe the nurse on her own decided to take a sexual abuse like kit, which you're not supposed to do. And there's really no evidence of it. And in fact, our forensic pathologist explained to us that a lot of people don't know, especially after death, like there are color changes around the rectum and anus that people often misinterpret as injury, but that's just like totally normal. So you see this a lot in shaken baby cases, and it's used to be like, well, obviously it couldn't happen the way they said because the child was also sexually abused. So Robert Roberson, it's a fascinating case. Actually the legislature, a bipartisan committee, got involved to stay his execution at the last minute. So many people have come forward. The detective who helped convict him has spoken out and said, I didn't realize that Mr. Roberson was autistic. And so I interpreted his, demeanor is like not proper for someone whose child is very sick and dying, which happens a lot with our clients who are mentally ill or.
They said that about me. I was nervous or
not nervous enough.
Not nervous enough.
No matter what you do, it's held against you.
They're going to interpret it as, you're guilty.
Right. So John Grisham has come out in support of him. Even Dr. Phil testified in support of him. Like all these news articles are out there, but he's still on death row and his fate hangs in the balance. And like, when I read his case, like I have trouble breathing because it's so similar to Lamont's. And this is the arbitrariness of capital punishment because like he easily could be Lamont. It just is, we were fortunate to get the right judge who gave us discovery, to get the coroner who had the integrity to admit her mistake. But also, like, Professor Garuli talked about 200 people who've been exonerated. Lamont's not counted in those 200 people.
Exactly. Because
he had to take a plea agreement to save his life. The real number of innocent people is so much bigger than that official exoneree number. And he took a plea agreement because the state doesn't want to give him compensation. They don't want to admit their mistakes. So that number is way higher. And I'm not going to go into it, so we have time for questions. But they pulled a lot of shady, funny business with the coroner's office to get every other coroner besides ours to produce what they called this consensus addendum to the autopsy report. It's literally those 4 sentences you see there, that basically just say, the pattern of injuries is not consistent with the story provided. The cause of death is severe traumatic brain injury, duh. The death of Trustin was due to non-accidental trauma, and therefore the manner of death is homicide, and the injuries to the rectum and anus are a result of an assault and not from a medical device. That's it. There's no explanation. There's no citation to the records. There's nothing. No one from this office would speak to a member of the defense team without the prosecutors being present. When they did finally speak to us, and I tried to ask them to like cite sources for things, they said, well, we wouldn't want to do your research for you.
Well,
We're supposed to be scientific, neutral experts, not like picking sides, right? So that's another whole soapbox thing that I could go into as well. So we did find out that the day this story broke, that Lamont was going to get a new trial, that the supervising pathologist printed the article out, drew a big question mark on it, and left it on the desk of the coroner who changed her opinion. So how do you think that makes someone feel, you know, about their job security and like telling the truth? And speaking of the truth, finally in Hamilton County, which is Cincinnati, Ohio, there's a new coroner who was just selected in the fall, but the previous, prosecutor, not coroner. Previous prosecutor had held office for a long time. And in one of my favorite statistics, in the whole country, just 2% of counties have put more than half of people on death row in America. So it's not like states with death penalties. I mean, it is, but it's really like these counties. So Hamilton County, Cincinnati, Ohio is one of those counties. And this prosecutor's office has this hanging on every wall of their floor. It's actually not, it's attributed to some Civil War general, but it's not actually accurate. But anyway, it says things like you can't withdraw under any condition. If you go, this line will be flanked. If you go, the enemy will sweep up over the hillside and take this entire army from the rear. You must defend this place to the last. I mean, you've heard like, you know, prosecutors are supposed to join in like the search for truth, right?
Justice.
It's not supposed to be win at all costs. But like too often this is the attitude. And that's like not cool. That ends up an innocent man like on death row. So.
Yeah. In the process, I wanna just go for a second about the reason why I took a plea to lesser charges. Enough was enough. They had taken my life, everything had taken everything except for my physical life. I took a lot of losses laying up in that cocoon on death row. My father was one of the roughest losses that I had taken. He's my real life hero. I looked up to this man. This man was salt of the earth, man. Everything he gained in his world, he gained it from the brow of the sweat of his brow and his hands. And I looked up to him. He was my hero. And when I was sentenced, the day I was sentenced, when they sentenced me to death, my father had a heart attack in the courtroom. It crushed him. We lost him in 2018. He didn't get to see me come home. But we still had our mother. My mother and my father had 58 years of marriage when he died in 2018. But we still have our mother. She's 85. She's elderly. Just a beautiful soul. So when the opportunity come for me to get back to my family, my children, my siblings, my mother, it was sort of a no-brainer as far as weighing the options of seeking compensation, you know, because if I chose that route, to go that route, the state had every intention on trying me again capitally and trying to put me back on death row,
Including for the rape charge.
including.
They were
for the-
still gonna try him for that.
And after conversations with my family, you know, my attorney, of course, there was one particular conversation I had with my son Lamont Jr. That was he was one of my children in those pictures. You know, my son said, you know, Daddy, it has never been about money. You know, it's always been about the truth and who you are.
And bringing you home.
And bringing you home, you know, and restoring you back in, you know, into the fold, into the family. We can, you know, we can move forward without the money. And it's never been about the money. It's always been about bringing you home. And so I decided to go ahead and, you know, accept the plea agreement. And in those negotiations, I learned about absolute immunity. Because at this point, I did want some retribution. I wasn't bitter, but I was, you know, I was angry about what they had did to me and taken from me, and my family, and my children. And so I was like, you know, something needs to happen to this prosecutor because there was Brady, we didn't talk about it, there was Brady material that we found in the prosecutor's file where they were just, you know, assassinating my character in every way they could to gain and maintain the conviction. And I'll wrap it up. But I learned about absolute immunity and so eloquently explained to me that you're not going to get this guy. You know, what he did is protected and go home. Let's go home. You know, and I like to shine a light on that absolute immunity around the country that these DAs, officers, and these prosecutors, overzealous prosecutors around the country, because, in my opinion, from my experiences, it incentivizes bad actors. We need prosecutors, good prosecutors in this country to hold people accountable for their wrongdoings. But things that happen to me and people like myself should never happen in this country. And prosecutors hide behind that wall of absolute immunity, and it incentivizes bad behavior from the bad actors. And I just wanted to shine a light on that. But that was one of the reasons why I took a plea.
Yeah, Lamont might still be waiting for his retrial if he hadn't taken the plea.
Still to this day.
Yeah. The Brady violation up there is they tried to say some injuries that Trustin had earlier, that Lamont had caused them as well, to also say that this was like a pattern of abuse. And they had things in their file, like this memo that says like, oh, there was an investigation. It was initially believed that Lamont had hurt Trustin, but it was determined that he had no contact with him. Yet they stood up in court and said Lamont had abused him previously. I just wanted to point out Lamont has a LinkedIn page that you can like connect with him on. And we have some flyers here that have the QR code for the Wrongful Conviction podcast, which is like a 40-minute episode that we did explaining his case. And he also has a GoFundMe because he, you know, didn't get any compensation. But anyway, you can feel free to take these and share them with people because more than anything, Lamont just really wants to share his story. So
Thank you, guys. I appreciate it.
Okay, well, thank you very much.
Thank you. Thank you. I appreciate it. Thank you. Wow. Thank you. That's number 3, right? Wow.
So we do have a couple of minutes, and so I do want to kind of open up for questions from the students. So if anybody has a question either for Erin or for Lamont, please identify yourself and then direct the question to which of our speakers. So, Lenore?
So, interesting thing, so a couple things about Habeas. Number one, as part of the Anti-Terrorism and Effective Death Penalty Act, says that we can only bring a claim that's based on clearly established federal law. Supreme Court has never clearly established that it's unconstitutional to execute someone who's actually innocent. So we can't bring an actual innocence claim. So we brought ineffective assistance of counsel claims, prosecutorial misconduct claim. But the other fun thing about habeas is that you can't bring a claim that hasn't first been presented in state court.
Exhaustion.
Exhaustion, yes. Lamont has learned it all. So when we got that discovery and that new evidence from the coroner, we basically immediately then had an unexhausted claim in federal court. So we amended our petition and then we're like, out, we have to go back to state court. So the relief ultimately came in state court in the form of a motion for new trial. And at the time, I said, I hope we never come back to federal court. I mean, it's there if we need to, but our hope was that we would get relief in state court and be done with it. And that's what happened.
Any other questions? We have a couple. Yes, go ahead.
Erin, can you speak about how your office got involved in the case or what that mechanism is to connect with?
Sure. So my office, the Habeas unit, is assigned death row cases by the federal court. So as I mentioned, Congress has given every death row inmate a right to lawyers. And so we keep track of all the inmates on death row as they're making their way through their state court cases. And so my supervisor just works with the district court when a case comes up. There's the Southern District and the Northern District choose the capital habeas units. The state public defender's office also has a death penalty division. And then there's something called the Criminal Justice Act. You might hear of like CJA attorneys. So there's some private attorneys as well that can get appointed. So sometimes there's conflicts. Like my office is only about 15 years old. And so some of the older attorneys maybe represented some people on death row in their state court cases. So they can't take them in federal cases in case they need to allege their ineffectiveness or something like that. So we just work it out with the courts as who has the capacity and is able to take the cases.
Okay, so I have a question for Erin. So Erin, you went to Notre Dame Law School. You were, I believe, executive editor of the Law Review.
As the note executive editor.
And so how did you get to this position? I mean, so what was your first position? What was your career path to get to your current position? So I clerked for Chief Judge Sutton on the 6th Circuit, and then I worked in the Columbus office of Jones Day. And this type of work was not on my radar at all. I didn't even take criminal procedure in law school. And so I'm just like the luckiest person in the world to have found the best job in the world. I did it through pro bono work because I knew from Fed courts and statutory interpretation that I found habeas work interesting. And so I started doing that in private practice. And even while I was clerking at the 6th Circuit, I found the criminal cases a lot more interesting and concrete than like fighting about the breach of the duty of good faith in a contract or something like that. But I probably didn't do it the right way because I wasn't really intentional about it. And you have to be to do this kind of work. I kind of put it, I took the path of least resistance, which is like, I did well and I was on law review. And so then the firms were just like, come work with us. And I was like, okay, because that's all who was coming to me. And I really wasn't like tuned in to the public interest world at all. And you have to work to do that. I work with the law student externs now at my office. We get a lot from Ohio State that has a whole separate office for public interest work, which is really wonderful. And they arrange on-campus interviews for the public interest offices, which is also like really wonderful. I got lucky. Before I'm going to call on Sil, just 1 minute. You and I over lunch yesterday, you made a comment that I found very, very interesting and maybe somewhat, you said that if you won the lottery today, you would continue working in the capital habeas unit. You get all the money that you needed, you would still continue working in that office. Why? I mean, me? This job. I'm just teasing. I mean, this job is a calling, right? And your job doesn't have to be, but like if you go to the trouble of going to law school for 3 years and spending all this time and effort to get that degree, I would hope that your job is more than just a job because you have these like skills and talents. And I wake up every day feeling fortunate and blessed that I get to use my talents in the service of something that's so meaningful.
And like, I tell like the painter who comes to my house that 2% death penalty statistic, like, you cannot stop me from talking about this stuff, right? Like, it's just like,
Passion.
I remember I was like telling my co-clerk about one of these insane cases and that our office has that nobody can believe, doesn't get, like, I'll just say this client was literally given truth serum by court order before he waived jury, and he's never gotten relief. So that's like the state of things because there's 6 dead bodies in his cases, and like that's all that matters, even though he might be actually innocent. And my co-clerk was saying like, oh gosh, good luck with like your terrible cases. And I was like, yeah, Sam Morton, well, Mott knows who it is, as he was on death row with him. And I was like, no, like, this is like the motivating thing about these cases. They're so terrible that like they need people to work on them. I mean, maybe you hear that and you're like, that's not for me. I mean, we lose all the time. Like, we make bad law all the time. And I know that going in. But to me, like, that's the motivating part. That's the challenge. And I'm not like looking, like we talked about, like we redefine wins. I cannot like define like whether I do a good job by like how many people I get off of death row, because that doesn't happen every day, right? And like, I can't control the facts, the law, the decision makers. This is a very political environment, but like there's things that people can't take away from me, which is how hard I work on the case, how I treat my clients, which is with dignity and in respect of their humanity. And like, sometimes that's the first time anyone's ever done that for that person in their life.
Absolutely.
And so like, it doesn't matter what the prosecutors or the courts or the Supreme Court or Congress or anybody does, but like, I can do that myself. And so it's the best job in the world because of that.
I can attest to that.
What's your attorney at trial appointed by the court?
Actually, no. Under the misconception of having a court-appointed attorney, you wasn't going to get any work done. But boy, was I surprised. This guy robbed my family blind and took off and went to federal prison. No, he was a private attorney.
A private attorney, but was he appointed by?
No, he was retained. He was retained.
The Death Penalty Information Center has done a study on 3 states, Ohio, Georgia, and North Carolina, and it's found that attorneys that contribute to judges' political campaigns
Absolutely
have much higher rates of being assigned these death penalty cases and have a much worse record
than any.
Absolutely.
That's one of the main problems.
This judge did have 2 appointed attorneys previous to hiring him. And when I hired him, the judge in chambers, I got a affidavit from the appointed attorney that said that when he came on the record and they stepped off the record, the judge told this attorney that we hired, don't make this a bench trial because he's going down. If you make this a bench trial, and he still convinced me to waive a jury and go have a bench trial.
The irony is that Lamont's attorney, who actually has been suspended another time while I was on representing Lamont, got suspended again. He's actually not a bad criminal defense attorney. He's like pretty good, pretty slick, like gets a lot of success. He was in way over his head in Lamont's case and thought he could do his normal sort of like dog and pony show, but couldn't when it's like all medical evidence.
I was sentenced. After I was convicted.
You were sentenced like 2 days before he signed.
2 days before he
signed his plea deal.
Signed his plea deal to go do 2 years for the crimes that he was guilty of in federal prison. He actually came to the jail on a Sunday and visited me. And there's no visits on Sunday in the county jail. And I asked him, what's going on, man? What are you doing here? I thought something was wrong with my family. I just want to talk to you about how federal prisons are. How federal, like, get out of here, man. send me back to, at this point, I've already been convicted, I've already been sentenced, and what do you want? I'm pissed. Now I see that you used me. It's
Yeah,
bad.
No, thank you so much, both of you guys, for coming here. So I'm a first year, and I know a lot of us want to do public interest work, and it's
Great.
hard, and we want to do, so much, and you're like bogged down, as you were saying. So this summer I'm doing exoneration work. What would you say would be like from both of you guys, the best things to keep in mind as I'm doing this? Because I know a lot of clients have gone through a lot of trauma, and it can be really difficult. And I know you had the source of light.
Of course.
If you have like any tips to use source of light.
What helped me and my family in these circumstances was my sister. We designated as a liaison to communicate with the legal team. Because let's face it, as an attorney, you're not going to have scholars as clients. You're going to have people that's been beaten up by society. You're going to have people that's been beat up by themselves, them families, people dealing with mental illness, trauma. Who's going to you can't reach them on certain levels to help them help themselves and help you defend them. And what we did was I was fortunate enough to have a family member to designate as a liaison to help with the communication barriers and stuff like that, which was in my case was the phone. But I would suggest that if you have a client who's difficult to deal with, who you can't reach on certain levels, to find a family member, a friend, someone who your client listens to and can persuade to be a liaison to get that communication barrier knocked down. It's very, I recommend it. You find a lot of success there.
And I'll just add what Lamont already said. He likes to say, try to meet your client where they're at. And that does require patience and understanding that, yeah, your client is dealing, he likes to say, I knew guys on death row who don't even realize that they're dealing with trauma. And he's like, I could recognize they're trying to do these coping things.
Coping mechanisms. They're trying to cope with trauma that they don't even realize that they're traumatized by, And it's weird seeing it. I learned a lot about myself so much being up close and personal to that. And it taught me how not to be so critical and judgmental of a person trying to figure out for no reason of their own how to cope with this trauma that they're suffering from, that don't realize that they've been suffering from it.
Right.
It's weird.
Yeah. I mean, we learn so much death penalty work is about mitigation. And so I've worked with so many, neuropsychiatrists and psychologists and brain scans and everything. And, one of the things I've learned is so much about our development physically changes the brain. So if you have people who are neglected or abused as children, this one expert likes to say what wires together fires together. Like literally parts of people's brain, like if they're not used, die off. And so if you've had a very healthy upbringing, you might be confronted with a stressful situation, and you might think like, okay, I can try to de-escalate by like talking to this person, or maybe I can just like walk away, or maybe I can get someone else to try to diffuse it, right? But like, or I could get physical, or I could yell, or like you have this panoply of options. But for people who didn't experience all those healthy options growing up, like they literally don't have those connections in their brain to do all of those things. And so if you have someone who's acting in a way you're like, they're not very appreciative, or like, that's kind of rude or whatever, like, it's not because they're rude. Like, they like literally might have a different brain than you're used to. You know what I mean? And it's not because they're ungrateful, but like I think Lamont says it best, like meet them where they are, and see what they need. Like Lamont, I just gave him the training I do for the law students in my office because he wanted to know everything about the process. Another client, like I look up video game walkthroughs for him because like that's what like gives him like the spark that like keeps him going. Like each client is different, and it's not one size fits all. And I think you got to get to know that client and gain their trust and be sensitive to what they want.
Exactly. And I want to write about it one day, the unique dynamic of being up close and personal and experiencing that. And me and Erin talked about that yesterday. So
Just thank both of you
of course.
for being just an incredible inspiration to all of us here in this room and at Notre Dame Law School. And please join me once again in thanking our special guest. Thank you. And for making Death Penalty Abolition Week a great success because of your presentation. So thank you again. Thank you. Thank you.